Ross, I think we had gone through the qualifications of the expert, the volunteer, and I think we're, I guess, to his opinions. So you may proceed when you're ready.
Thank you. I was actually going through a laundry list of items, Mr. Bedard, that you had gotten from my office to review. Do you remember those questions?
Yes.
All the depositions you had a chance to review?
Yes.
All the police reports, narratives, all the information that was provided to you, you had a chance to see. Is that right?
Yes.
Okay. As a result of looking at all of that, reading it, listening, do you believe that you have a firm grasp of what happened in this case?
Yes.
And let's go to some of the questions. At some point, you were asked about reviewing the Holly Hill Police Department's policies and procedures in your deposition. Do you remember that?
Yes.
And at that point, you said, no, but that's what you'll do immediately, depending upon how far this thing goes. You remember making that statement?
Yes.
And now, as of now, have you now had a chance to review the Holly Hill policies and procedures?
Yes, I have.
And now, having read them, do you remember what year or updated they are?
2012, I want to say February 2012, I think is our recall.
Do you know whether or not it's also any higher than that?
I don't recall specifically.
Having reviewed that, does that help you to formulate opinions in this case as well, having now reviewed the Holly Hill Police Department's policies and procedures?
I think it's more supportive of my opinion, yes.
And have you ever reviewed or are you familiar with the Volusia County Sheriff's Office's policies and procedures?
Yes.
And that's also based upon the last case that you had here that you were involved in, that you reviewed that, is that right?
As well as two others that they sent me.
And how about Daytona Beach? Have you reviewed Daytona's policies and procedures?
I believe I have in the past, because of my close connection with a lot of the Daytona Beach police officers through training.
So, having reviewed Volusia County's, Daytona Beach's, and Holly Hills, do you believe that you're in a position now to formulate opinions based upon your expertise to render opinions in policies, procedures, tactics, and defensive tactics? Right?
Yes.
Now, in talking about use of force and defensive tactics, are you familiar with the use of force continuum?
Yes, I am.
And what is that?
The continuum tries to position perceived levels of resistance against officer response.
And is that same or similar to the strength or force matrix?
It is essentially identical. As a matter of fact, force matrix is a term that the state uses because it was found out a few years ago that the term force continuum was a trademark term.
Okay. And so what does that mean to you?
What does
The force continuum?
Okay, so the force continuum, as I indicated, pairs officer response to perceived levels of resistance. It has really two major components. One of them is the idea of escalation and de-escalation in light of a changing threat. And then the lateral line is one of proportionality that says that under this set of circumstances, this is the recommended level of response. So it maintains proportionality throughout.
Do you know whether or not the force continuum is any longer being used by the Florida Department of Law Enforcement as a training tool?
Yes, kind of. It was used as a training tool for basic recruit curriculum until 2007, I believe, at which time we decided to, and I was on this committee to do this as a subject matter expert, to get rid of it as a training tool at that level. And the reason that we did that is because many agencies have their own form of the force continuum, and we found it was just confusing officers that went through a more broad study of law enforcement after they went to their respective agencies, they now learned another continuum with perhaps different terms or different visuals.
So as we look at this case, before I start asking you questions regarding this case, would you apply the force continuum in this case as it relates to opinions and responses there too?
I would. I still use it, as many agencies still do.
And is that even based upon the potential use of deadly force as to its perceived observations, or de-escalating in perceived observations?
Yes, the continuum goes everywhere from initial contact to the use of deadly force.
What is a linear continuum?
There are different kinds of continuums, and continuums operate philosophically, if you will. There are circular continuums that would show a graphical interface that had one arrow perhaps circling into another one. There are colored continuums that would show perhaps if your metaphor was color, you go from blue to red and go through the yellows and the greens as things got more aggressive. A linear continuum is really a two-dimensional description of force that is separated by a line in terms of force going up and force coming down. That's the linearness of the continuum.
So going back to policies and procedures of the three different agencies that we talked about, do you know whether or not the force continuum would be different in each policy, or would it be identical or same or similar?
It would be same or similar.
And why do you say that?
Depending on, because I don't have those other policies in front of me, but depending on when or where the policy was written, many agencies follow FDLE, much to my recommendation against doing that. If FDLE gets rid of it, they get rid of it. And I think part of that is a misunderstanding what the role of FDLE CJSTC is. It is to train non-cops to be cops versus an agency's task to train cops to be better cops. So many of them have gotten rid of it now, but certainly everyone is trained to the philosophical underpinnings of it, which is escalation, de-escalation, and proportionality.
Well, do you think that there's variances in between the various policies and procedures as it relates to this force continuum?
There's variances in terms of description and in terms of labeling.
Is there a national standard for the variance or for the specific standard of force continuum?
There is a national standard where a variance may occur. Somebody might entitle, for instance, deadly force and lethal force. That would be variance, but it would mean the same thing.
Is safety the first goal of a force continuum? For a law enforcement officer to make sure they're safe?
Yes, but I think you have to take it one step further. The force continuum deals with authority. In other words, authority is assumed. The force continuum assumes that the officer has authority. One step previous to that, safety is not the first goal. The first goal is proper transaction, which is authority.
Is there a goal to avoid excessive force?
Is there a goal to avoid excessive force?
Yes.
Yes.
And what do you understand as far as the objective standard, if any?
Objective reasonableness can be contrasted with obviously just reasonableness or subjective reasonableness, and I think it's often confused in one of the areas that I'm asked to talk about quite a bit, both in lectures and in the classroom and in court sometimes.
So what is objective reasonableness?
Objective means that something complies with a authoritative standard rather than a personal standard, which would be a subjective reasonableness.
So when looking at this case, as it's applied to three different potential agencies, or at least two, do you look at a subjective standard or do you look at an objective standard?
I look at an objective standard.
And would that be the objective reasonableness standard? Is that
Yes.
what you're looking at?
Yes.
So do you formulate your opinions irrespective of what agency is involved based upon an objective reasonableness standard?
Yes.
And how do you determine reasonableness? Is that something that you think is reasonable and someone may not? How do you determine an objective standard of reasonableness?
Objective or just reasonableness?
Objective.
Objective reasonableness is really a comparative analysis that the actions comport with essentially federal law, state law, policy, and training. And within policy and training is, of course, continuum. Within policy and training are certain techniques. If the actions of the officer comport with what we taught them, what the policy says they should do, what the state allows for, and the federal law allows for, then we would say it is objectively reasonable, since those are authoritative values. If it is somebody who simply says, I wouldn't have done that, that would be a subjective analysis.
Is it accurate to say that the goal is to get the maximum amount of control with the minimum amount of force?
Yes.
Is the goal to be reasonable?
Yes.
And would you look at it based upon hindsight or foresight of the officer who's involved in it? Meaning, do you work backwards or do you work forward when I ask you these next perspective questions I'm going to get to about what was appropriate, what was reasonable as versus objective?
You work forward. You try to put yourself in the shoes of the officer that's making decisions at the time they're making it, rather than looking at it with the benefit of 20/20 hindsight.
Now, in looking at the entirety of this case, would you say this was a good case or a bad case?
I try not to put moral labeling on cases as good or bad. I can tell you what's objectively reasonable, and I can tell you, in contrast to that, what may be objectively unreasonable from a police procedures and training perspective.
Okay, so what about the procedures as far as the Cocoa Beach Police Department in this case that you would say?
I think there are very specific procedures that I assume you'll ask me about that are objectively unreasonable.
How about the fact that Officer Dale Kelly made or attempted to make an arrest without a warrant? What is your opinion on that? On a misdemeanor matter.
Right. I mean, there are some exceptions to the warrant requirement, depending on what the crime was. In this case, I think he felt that it was perhaps a domestic violence. I know a full investigation had not been conducted. We hadn't even talked to the other party, and domestic violence being what it is, there is always a second story. But if there was probable cause for a domestic violence, then the officer could have been legally, objectively, reasonably capable of making that arrest without a warrant.
Based upon your knowledge and understanding and reading all of the documentation as you have up until today's date, what do you think the reason was for Officer Dale Kelly wanting to go to the house on Flamingo at 1:30 in the morning, more than 3 hours after the alleged battery?
I'd be speculating. I still struggle with it. I can't imagine.
Well, do you know of any compelling reason that would have existed to go there maybe 3.5 hours later, or 1:30 in the morning to a residential location without a warrant?
I don't.
Do you think there's a compelling reason to help somebody to get their personal items at 1:30 in the morning out of a house that they allege that they live in?
I think there's a reason, but not a compelling reason. That's not, it's an unreasonable decision to make based on that circumstance.
So even if you believe that, or do you believe that Dale Kelly had a probable cause at the time of going to the house at Flamingo?
Objection calls for a legal conclusion. This is my whole objection to this whole line of work is the only way that reason or even is to make a legal conclusion.
Okay.
And we believe that an expert can make a decision as to a legal conclusion. And there's case law on that point, that's why you bring an expert in, because they can opine and have an expert opinion.
Okay. I'm going to overrule the objection, but it's without prejudice when we consider essentially the entire objection that you have in your motion.
Yes, sir.
So
Thank you.
we'll address that at that time.
So, did you make any opinion based upon a review of the documents, the information, the items that you listened to, all of it in totality, whether or not you believe that Officer Dale Kelly had probable cause, or did you even come to that decision?
I did not. It's not my task to assign the validity of probable cause. I do believe that he was conducting an investigation, so I do believe that there may have been grounds, there may have been a reason, there certainly was a reason for conversation with Mr. Morrison, but I think it's unreasonable to have done it under these given circumstances.
Why do you say that?
He was in his house, that they were banging on the door. He wasn't coming out for the longest period of time. It was 1:30 in the morning. Secondly, you had the victim of allegedly domestic violence with you, and that is a basic tenet of domestic violence investigations, that you don't bring couples together, you separate them. There's just so much wrong with this.
Okay, well, let's break it down. Assuming that arguendo, that he had probable cause to make an arrest, would you have believed, based upon your degree of reasonable probability as an expert in this case, that he should have gotten a warrant?
Yes,
Why?
he was in his house.
And are all arrests considered assumed to be invalid without a warrant?
They are on the surface.
So do you work backwards from there?
Work backwards from there.
You work backwards from there as to why you needed to arrest somebody with a warrantless arrest based upon perhaps exigencies.
Officers are compelled to get a warrant unless there's a reason why they can't. There's some foreboding reason that they reasonably believe would not permit them the time or the opportunity to get a warrant. So I guess you would work backwards in considering the facts that you now know that didn't know perhaps even when the crime was first occurring.
Did you believe that, based upon the information you were given, that there was any exigencies that necessitated going there to arrest him 3 hours later at 1:30 in the morning?
No.
Now, did you have any further understanding as to the story that was given to Officer Dale Kelly from a person who may have been intoxicated? Is that what you understood?
Is the question, did I understand that she might have been intoxicated?
Yes.
Yes, yes.
And do you know whether or not there was a second witness and what condition that witness was in as well?
There was a witness across the street that saw some event from a distance happen at the roadside. I don't know that I recall the condition.
Assuming that there's at least one intoxicated witnesses or two intoxicated witnesses at 10 or 10:30, what do you think the prudent thing to have done would have been?
Since there was no safety reason to do anything extreme, probably the best thing would have been to stabilize the situation. For instance, if the victim in what may have been a domestic violence wanted to pursue this, there are more reasonable hours to do that. If you want to get an injunction or you want to get counseling, typically we don't call it out, certainly on something where there's not even a serious injury. We would not call anyone out at that hour, so they should have stabilized it.
Would it have been more prudent for them to have gotten a warrant?
Yeah, well, I think at that point they couldn't have gotten a warrant. I don't think there was enough information to have done that. But yes, that would have been the ultimate end game of a law enforcement officer who was trying to put together a criminal case, is to establish probable cause that crime was committed, and to take that for review and ultimately get a warrant before proceeding.
And do you know whether or not Officer Dale Kelly or Sergeant Rod Erdman or Corporal Matt Armstrong got a warrant in this case?
Certainly not when the event happened, no, they did not.
And you were talking about taking the alleged victim in a domestic violence to the alleged perpetrator. Why do you think that's wrong?
Well, tactically, it's a bad idea. Domestic violence implies that there's danger to somebody or perhaps both people. The first thing we do in any situation, whether it's a gang fight or a mob riot or domestic violence, is we separate people. We also have a situation in terms of investigation that is compromised by the psychological control that is often observed by law enforcement officers that an aggressor will have on their partner or the victim of their violence. So if it's a situation where we can't separate them, we will often turn them around so that they can't make eye contact and be overtly influenced by the person who is sending the signals that perhaps they shouldn't tell law enforcement officer what they need to know.
So in this case, based upon your understanding of the various policies and procedures of the agencies, do you think it was better to separate the alleged combatants in this alleged domestic violence case?
Well, they were separate. I mean, when the officers responded, they were nowhere near each other. I think they were different cities.
And do you think it was prudent for them to put them together?
No.
Or in the same proximity, so they could somehow meet each other again?
I think it was the violation of the most basic tenets of investigation and training. We would not do that.
Is it your opinion that it wasn't the best decision, or did they do something that you believe is illegal?
At what point?
When Dale Kelly, or Officer Dale Kelly, met with Corporal Matt Armstrong at the Crystal Burger along with the alleged victim, Miss Mays, Leah Mays, and took her to the location on Flamingo Drive.
I think it wasn't the best decision.
But you don't think it's illegal?
I don't think it's legal to bring her over there.
At some point when they went onto the property and they knocked on the door, do you know whether or not they actually announced, when I say they, I'm talking about Corporal Matt Armstrong or Officer Dale Kelly, whether they actually announced police when they first knocked on the door?
I don't know for certain.
And if you found out, and I want you to assume, based upon a reasonable hypothesis, that Matt Armstrong, Dale Kelly may have banged on the door but did not announce police officers, would that help you or prevent you from forming an opinion at that point, whether or not they were proceeding within the proper policies and procedures of the organizations of the Holly Hill Police Department or the Daytona Beach Police Department?
They should have announced their presence.
And their failure to announce their presence at 1:30 in the morning while banging on the door, how does that affect your opinions and your beliefs, if any?
I think it would have placed a reasonable person on alarm at anyone knocking on the door. Certainly without identification would result in a reasonable person becoming more alarmed than, for instance, if it happened at 1:30 in the afternoon.
So at some point, when you found out that Corporal Matt Armstrong, Officer Dale Kelly, went through the chain link gate as well as the wooden gate, what is your opinion on that?
My opinion on that at that point is that the officers were actually believing he was not home. She was insisting that he was. I think, according to what I read, that their ambition at that point changed under the reasonable belief that he either A, was not coming out, or B, wasn't home. And that they started to focus on what they later said was a assist on behalf of Ms. Mays to collect and gather some items.
And do you think that's appropriate to assist in the collection and gathering of items at 1:30 in the morning by breaking into the back of the house, going around the curtilage, and into the house itself, crossing the threshold up to the window and breaking the window to get in?
No.
What about jurisdictional problems in Officer Dale Kelly asking for the assistance of Corporal Matt Armstrong from Holly Hills in order to utilize his jurisdiction of Holly Hills to aid and assist in this investigation, apprehension, arrest, so forth and so on?
It's not terribly uncommon.
Do you believe it would have been a better choice for Officer Dale Kelly to get in touch with the Sheriff's Department, the Volusia County Sheriff's Department, instead of another municipality?
Yes.
And why so?
The Sheriff's Department is a constitutional office that has greater jurisdiction. It is also, in this particular case, I think the one who controls the jail. So you start getting into issues of crossing boundaries. You need to have rather than a corporation who is facilitating you, a constitutional office has greater jurisdiction in various areas.
Do you have an opinion based upon a reasonable degree of certainty as an expert in this area, whether or not Officer Kelly was trying to get a Confederate to be able to make the arrest based upon what happened in Daytona Beach by soliciting Corporal Matt Armstrong?
Confederate may sound a little insidious. I think he recognized that he was in a different town and was relying on an officer that clearly had a jurisdiction in that town to help facilitate his ambition. I don't think it was. Confederates are usually a ruse, and that's why the word, I think, is troubling to me.
What about fresh pursuit? Are you familiar with that?
I am.
Was this a fresh pursuit type case?
No.
So do you believe that crossing boundaries of municipalities is appropriate if it's fresh pursuit? But in a case of this nature, do you have an opinion whether or not they should have waited and gotten a warrant?
My opinion is they should have gotten a warrant if they could have formed probable cause.
So in your opinion, is it wrong for a Daytona officer joining up with a Holly Hill police officer at 1:30 in the morning to accomplish a potential or possible arrest and to assist an alleged victim in getting herself home?
Yes.
Would you agree that probable cause, as you know it, is a question really for a jury, not for you?
Yes.
So when you think about the end story, that Mr. Michael Morrison was shot inside of his own house, what do you think?
I think it was egregious.
Why is that?
I think the officers, beyond not following policy and procedure,
How? How so?
well, we spoke about some of it. I mean, making an arrest on this type of a case without a full investigation would have been a violation of certainly Holly Hill's policy, as well as, I'm sure, Daytona's. I think that the officers were reckless in moving around the outside of a reasonable person's house at night surreptitiously. With, as we found out later in hindsight, you know, Mr. Morrison didn't know that they were there. I think he said he was in the bathroom, he didn't hear it, which is a transactional problem in and of itself, because there's no communication coming from inside the house before you start going around the backside of the house. I think it would have caused alarm in a reasonable person.
Let's go back to one of the foundations of this case as well, is that, as you know, or do you know, that Officer Dale Kelly may have believed that Miss Mays lived there at this location on Flamingo Drive.
What was the question?
Did you have knowledge that, from your reading, that Officer Kelly with the Daytona Beach Police Department may have believed that Miss Mays lived at the location of 805 South Flamingo Drive?
I don't know, I can't say what he believed, but I know that she did live there.
And how do you know that?
She was not a resident there. Her name is not on any of the, it's not on the property appraiser's list. It's not on her driver's license. It's not on some type of ID card. She's not getting mail there. She's not living there.
Your Honor, I'm sorry, 1 second, back there, please. Your Honor, I'm sorry, just if I could have 1 second, please. Okay. So you're familiar with filling out a victim witness statement that victims fill out in their own handwriting?
Am I familiar with them?
Yes.
Yes.
Are you familiar with confidential law enforcement victim notification cards?
Yes.
Asking victims to put information as to where they live and so forth and so on?
Yes.
So they can be contacted? And in looking at the documentation that I provided to you earlier, did you get a chance to review the victim witness statement as well as the confidential law enforcement victim notification card?
Judge, I'd object if they're trying to introduce these items of evidence of their hearsay, and I don't think you can properly authenticate those through, you know, an expert who says they're in a file, same as we had discussed earlier.
I'm only asking if it helped to refresh his memory as to his knowledge and memory of what transpired in those documents. It's for matters of refreshing, it's not for introduction of evidence. I didn't have him marked to introduce them as evidence.
I'm going to sustain the objection because I don't think you've established that he has no recollection of the documents. Should you do so, then obviously it's something different.
Thank you.
And I do think that expert witnesses can testify with regard to matters that they've reviewed, as long as they're, as long as you meet the predicate requirements under the
I
statute.
was trying to set the foundation. Thank you, Arnold.
Okay,
Go back.
may I
Let's
proceed?
try again. Sir, in looking at all the documents that we talked about that I briefly and scantily went through, without naming each and every document that you received, do you recall receiving anything regarding the victim witness statement and/or law enforcement victim notification card that was filled out on the scene?
Yes,
And do you remember it precisely?
I do not.
And would looking at the documents help to refresh your memory?
Certainly.
May I approach the witness?
Okay?
Thank you.
Okay?
Thank you. Now, having looked at those documents, please turn it back over. Does that help to refresh your memory?
It does.
And even at or after the scene, did you have knowledge at the time of where Miss Mays believed that she lived or wanted any and all information sent to?
Yes.
And where was that?
Ridgeway, is it South Ridgeway?
Is that the 408 Ridgewood Avenue?
Ridgewood, yes.
Okay, thank you. Now, does that counter, can I take it, Judge, can I approach the witness?
Okay.
Thank you. Considering that, did you know that, or what is your knowledge of how they got Miss Mays to go with them, from what location to go out to Holly Hill?
From that location on Ridgewood, I understand that they were at her home and left from there.
So did you have some understanding in the formulation of your opinions and beliefs in this case that it was actually Officer Dale Kelly that went to that 408 South Ridgewood Avenue location to pick her up where she lived?
Yes.
And so did you formulate an opinion yourself based upon all the information that she lived anywhere else other than the 408 South Ridgewood Avenue?
No.
Now, considering that, and considering policies and procedures of Holly Hill and the Daytona Beach Police Department, those two that being involved in this, what is the appropriate procedure and policy for validating when someone says they live somewhere else? What do you do?
You do what you can. I mean, there are limitations. We have many cars that have a system called David, which runs driver's license and identification cards. You start there.
You said the name is David,
Yes.
and what does it stand for, do you know?
Driver vehicle identification, I don't remember the exact acronym. I've known it too long, I don't recall. But it is a system that is internal to a lot of cars that if you don't have it in your car, you can radio dispatch. And dispatch would run what we call a 29 check. You can run a DL check, you can run an ID card check. If you don't have a driver's license or an ID, there are other ways of doing it. Certainly you can search the property appraiser's records. That's available to everyone. You also can do what we call a wants and warrants check. This is somebody who perhaps has been arrested for the most minor of offenses. It will come up with the offense, if there are any outstanding warrants, and it will also generally give an address or a series of addresses that the former arrestee had declared at the time of that arrest. So this is an officer's due diligence in trying to determine where somebody lives.
So if you found out that 9 months prior to this situation, on January 21st, 2012, that the officer, I believe Matt Armstrong, arrested this victim and gave the same or similar address on South Ridgewood Avenue, do you have an opinion, based upon a reasonable belief, as an expert in this area, whether or not the officer should have believed that she lived in Holly Hill, where the alleged perpetrator of this crime lived?
I think he could have given her the benefit of the doubt, and 9 months previous, she may have lived somewhere else, I don't know, based on the question. But there still is a due diligence that must be conducted before you allow somebody to go into property that you cannot ascertain is belonging to them.
So what other due diligence would you do besides looking at David, looking at prior cases, assume the person doesn't drive, doesn't have a driver's license. Would they have a Florida ID card?
They could.
What else would you do before just accepting the statement, I live there? as
Sure.
well?
I want to be clear, because when I say this, I may afford a misunderstanding. That would be essentially the end of the investigation, because I don't believe they should have went to Holly Hills. But because they did, if you wanted to continue with due diligence, based on my experience, there are several things I could do. One, I could check the mailbox, see if she had mail inside the mailbox that had her name on it with that address. Two, I could run the vehicles that were outside, generally speaking. When people live somewhere and they're without a vehicle, they may have a vehicle there. You could run the tag, you could see if her name were on any of those kind of things. I mentioned to you the property appraiser's office. If it was that important, you could perhaps even call or go to a neighbor and say, is this your neighbor, do they live there? Just to gather sort of a composite of information, give you confidence, and this is about
And
confidence.
if the neighbor lived next door, who is the landlord in that building, and the landlord that she rents from, would that have been an appropriate thing to do?
Of course.
So would it be appropriate then for, based upon a reasonable degree of probability and or certainty as an expert, that Corporal Matt Armstrong and Officer Dale Kelly should then rely upon what Ms. Mays said and then watch her commit a trespass to the property out at 408 South Ridgewood Avenue, and or even potentially criminal mischief or a burglary by breaking out the window and trying to enter?
I'm sorry, I lost the question. Start with,
Okay.
if you could rephrase it for me, please.
Do you believe it appropriate that these officers, based upon the limited information they knew of where she lived, to allow her to commit a potential trespass?
No.
Do you believe it proper, based upon a reasonable probability as an expert, that they should have allowed her to commit a criminal mischief by breaking the window?
No.
Do you think it's proper that they should have allowed her to break in to a house by breaking the window of a house she doesn't own or have any documentation to be there for?
No.
Do you have any opinion based upon a reasonable degree of probability and or certainty whether or not officers Dale Kelly and Corporal Matt Armstrong facilitated Ms. Mays in committing several crimes?
I believe they did.
And what crimes were they?
Trespass, I believe, criminal mischief, or sometimes called vandalism in our state.
For the sake of argument, assuming arguenda that the police believe she lived in that house, would it be legal for her to break into her own house?
If she indeed did live in that house, if they knew that she lived there, I'm sorry, is that your question?
Yes,
Would it have been okay for her to break into it?
yes.
She could have.
So do you believe that at 1:30 in the morning, it would have been appropriate, even if the person lived in the house, to allow them to break out the window at 1:30 in the morning, considering neighbors in the street and so forth that you were on?
I don't think it would have been appropriate to allow them or facilitate them, but if they did it would not, and indeed they lived there, it would not have been a crime. The consequences of it that would be found out at a later time would not result in her arrest.
Do you have an opinion based upon a reasonable degree of probability and or certainty as an expert, whether or not the two officers, Corporal Armstrong and Officer Kelly, were inviting her to engage in what is allegedly a domestic fight between a guy who's in a house perhaps armed at 1:30 in the morning?
I think they knew or should have known that was a likelihood.
Do you believe that their decisions were right or that their decisions were bad all the way around?
Again, I hate to assign that title to anything, but to say that all the way around they were objectively unreasonable.
Is that a standard of objectiveness? And I know you said objectively unreasonable, or is it a standard of subjectiveness?
It depends on who you ask. I would say, for me, it's a standard of objective reasonableness. That's what I'm tasked with determining. I think others would have the opinion, under common sense, if you would, that it was wrong.
Now, having this opinion, I'm sure you're gonna be asked, well, anybody else who's an officer for 30 years may have a different opinion. How is it that your opinion is more of an expert opinion than a road patrol officer with 30 years?
I would say it probably has more to do with the instructional side of what I do, having to understand these things in their minutia so that I can train officers to do it right. I can speak to what officers should know as well as what officers have done. And what officers should know should be the criteria of determining whether somebody had lawful residence before participating in what we later found out was several crimes by definition.
You write training manuals?
Yes.
And having to write training manuals, you have to have knowledge that's more intense and direct than those that may be applying that policy and procedure?
Significantly.
And how is that?
You deal with nuances that encompass a larger swath of possibility. You also reflect on things that have happened to help shape your understanding of what should happen. And so the research that you have to do to get to the recommended policy method or the procedures that are used is profoundly greater than a person who sits in a classroom and receives essentially the tail end of all that research, which is the conclusions that the researcher has gathered or has settled on from the gathering of information. So I represent, from a training perspective, as both a field training officer and a classroom instructor at the academy and in service, significantly more information than your average patrol officer.
Now, in the area of your expertise in policy writing and the various things that you do you have knowledge about the Fourth Amendment?
I do.
Did you have to go to law school to get that knowledge of the Fourth Amendment in order to write policies and procedures?
No.
Where did you get that knowledge of?
I got it doing the job. I got it at the academy. I got it from, subsequent to the conversation which previously just occurred, I did have some classes on law. I've worked with lawyers and presented at various conferences. Then I've also sat through the dealt with Fourth Amendment issues. And you ring a bell when you say this, because these are what people who deal with police, in particular civil liability, as well as criminal liability,
So in the past, when you write these policies and procedures involving police pursuits and various other aspects of it, and it involves Fourth Amendment implications, do you go through it with attorneys and judges and those people as well?
when I write them.
Yes.
Not when I write them, but oftentimes I will have colleagues that are lawyers, sometimes doctors, because I deal with defense and tactics, so I'll take a review. I formalize the process. As a matter of fact, my process is used by the state right now, as well as other agencies.
And what agency did you write these policies for?
The Florida Department of Law Enforcement Criminal Justice Standards and Training Commission.
Did you write it for the Tallahassee Police Department?
I have done that as well, yes.
Have you been sourced by other international firms as well?
Yes,
Have you written policies and procedures for Mexico City?
I have.
Have you written policies and procedures for the police in Germany?
Yes.
And does that give you a greater expertise than the other veteran on the street of just driving around for 30 years? And I'm not suggesting that they're not doing a public service.
I would think so.
Now, are you basically saying, as it boils down, that the police officers, Dale Kelly and Corporal Matt Armstrong, should not have taken Miss Mays to the house located at 408 South, 805 South Flamingo Drive?
Under this set of circumstances, yes, that's what I'm saying.
In in looking at the totality of your experience and your life involving police officers and police work, would you say that you were more directed toward creating schemes or schemas in which police operate rather than focusing all the time on the grunt work of patrolling the neighborhood?
I'm not sure I understand your question.
What has basically been your career in existence for as a policy writer and as a expert in training and self-defense?
Okay. Yes, I create schemas and models for the purpose of instruction. I would tell you that that's more than likely why I got into police work. I was a field training officer as my first job, and I maintained it throughout my full-time career.
Is there any certifications in probable cause? I mean, can you get a certification as being an expert in probable cause?
As an expert, no, but I'm sure there are people that teach classes that would certify you on the elements of probable cause.
Can you be certified in domestic violence
If somebody's teaching a class on domestic violence, it will give you a certificate, yes.
or trespass or burglar? Can you be certified?
If somebody's given a certificate, they're not of any grand authority.
Is this something based upon your experience and your knowledge and your expertise?
Yes.
What you've learned over the course of 30 some odd years?
Yes.
Now, at some point, do you recall whether or not Officer Dale Kelly tried to contact or did contact Mr. Michael Morrison before going out to the house out there at 805 South Flamingo Drive in Hollyhill?
I think he did try to contact him.
And based upon the conversation that you recall reading about with Officer Dale Kelly and Mr. Morrison, do you recall what was the finale of that conversation?
I don't recall the details of it, except I think that Mr. Morrison did not want to have any further conversation.
Do you know whether or not that it was left to leaving it to his lawyer to handle and not coming out to meet with Dale Kelly?
I seem to remember that.
Would it help to refresh your memory to look at your deposition on May 25th, 2016?
It may.
Page 51. May I approach the witness?
Are you,
That's all right.
You want to read it, I don't care. Just move it along. If you want to read whatever part you're trying to get out of the deposition, I don't have an objection to it.
Okay. Question. All right, so going back to the facts of this case, you're saying that you didn't believe there was probable cause to make an arrest that night. Answer. There may have been probable cause to make an arrest. I don't believe they had a warrant to go into the home, which they knew that they were going to have to do, because apparently they called him and he said, I'm leaving it to my lawyer to handle it and I'm not coming to you. The alternative in showing up there would have been to break into this house, and that would have been patently illegal. Do you remember saying that?
Yes.
What did you mean by that?
This attempt at an investigation, as I indicated previously, the officer, I don't fault the officer for investigating domestic violence. They were told that he had done something that was important for them to determine whether or not there was veracity in this, and that would require a conversation with him. But he invoked a lawyer, and as a result, put an end to the conversation.
Well, you know, the state may say, well, what's wrong with the fact they told her, you do whatever you think is right? They didn't break into the house, the officers. What do you think about that?
I think they went with her. They helped facilitate it by helping her up onto boxes and hanging on to her and all that kind of stuff. So they were very much a party to this. I think if this were a criminal case, not to suggest that it is, you would call them co-conspirators.
But let's assume, arguendo, as we use in court and law, that they did not help her physically over the fence or through the gate, and they didn't physically help her, hold her to break the window, but they said, whatever you want to do, it's your house, you say you live here, go through the gate. Whatever you say, you live here, go over the gate. Whatever you say you live here, break the window, but hurry up. What do you think about that?
I think it was all around bad advice. I think certain law enforcement officers act sometimes in the capacity of counselor, and I think that was poor counsel to give her.
Why do you say that?
Well, it's easy to say now in hindsight, we know what happened, but when you go back and you look at what the officers were trying to do, which I'm still not sure what they were trying to do, but they say that they wanted her to get her belongings. I contend she should not have been there at all, certainly not under their vehicle power. If she was going to go out there, it would have been on her own. Law enforcement would have a hard time preventing her from doing that if she were to get into a taxi or an Uber, for instance. But the onus would be entirely on her if, in the event she kicked in a window and it was determined that that wasn't her house, then she would be subject to arrest for breaking this particular piece of glass, perhaps for burglary, perhaps for trespassing. So the officer should not have been party. Having been there, I think it was the onus was on them to provide her sober counsel as to what she probably should do. But they introduced her into that environment, so they are party to it. It wasn't just that they were giving her bad information or bad advice, but rather were party to what she did.
So does the question go back to reasonableness?
Yes.
And do you consider whether it's reasonable or objectively reasonable for a police officer to take somebody's claim of living there, intoxicated woman, and taking her back to that area? Is that what you look at?
It is objectively unreasonable to do that.
Are you familiar with the Castle Doctrine?
Yes.
You have to be an attorney to understand the Castle Doctrine issues.
No.
Have you learned that?
Yes.
Was there anything about the Castle Doctrine that you thought important in this case as it's applied to Mr. Michael Morrison?
Yes.
And so what?
Yes. So my analysis of this is, it goes back to the whole authority issue. When a law enforcement officer is acting outside of their authority, they don't even enter into the force continuum. It doesn't apply because that is the term of escalating and de-escalating. Faced with force while you have a lawful authority over something. This is not that case. When police officers do things that exceed their lawful authority, you can't really look at it from a use of force defensive tactics perspective. You have to look at it really from a more civilian perspective, which in this case, the officers were not conducting a bona fide law enforcement practice. What they were doing was acting as independent individuals that were facilitating another civilian in breaking into the house. Now, because of that, it calls into question the Castle Doctrine. The idea that all people in the state of Florida, and arguably anywhere in this country, have a natural right to use self-defense. Now, this natural right, as it's referred to as the Castle Doctrine, goes back to about the